Hi, and welcome to this edition of Ask an Attorney, joined today by Tyler Siewert from Schweiger, Clemeen and McBride. Thank you so much for being with us this morning.
Glad to be here.
Let's take a look at our question. My son was badly injured in a youth sports league. The medical bills are piling up, but the sports league is refusing to pay for them because we signed a liability release and waiver. Is that release and waiver valid, or will the league have to pay for my son's medical bills? Pretty common question, isn't it?
Pretty common question, excellent question, but a very difficult one to answer. So as some people may know, a liability release is a contract through which an individual essentially states that he or she is not going to sue some other party or hold them responsible for any damages or injuries. And the first issue we need to address with these liability releases is to check if the terms are valid and enforceable. And then beyond the actual language of the liability release, the second thing we need to understand is that there are going to be a lot of different variables that can and will affect whether or not the sports league is ultimately responsible to pay for these medical bills.
Okay, let's go back to that point. How do we know whether that is the terms of the liability release are valid?
Right, so to begin with, it's important that we understand that courts do not look at liability releases favorably. And in fact, liability releases are strictly interpreted against the party being released. And this is important because courts can actually invalidate any liability release that is ambiguous or otherwise susceptible to multiple interpretations or meanings. So for instance, I've seen some liability releases that merely discuss waiving liability for medical expenses, but they're completely silent on other sort of expenses like wage loss or other items of damages. So in those situations, courts have actually invalidated those liability releases because they failed to clarify which elements of damages are actually being released or waived. And second, it's important to understand that here in North Dakota, any sort of contract attempting to release a party from any intentional act or any act that they intended to cause an injury, well, those releases are going to be invalid as well.
Okay, so really it could come down to whether this injury was something that happened by accident or if it was something that happened on purpose.
Yes, absolutely. And let's just say, for sake of hypothetical, that this injury occurred during a youth football league.
Okay.
Perhaps one of the drills at practice was a little too aggressive, or people are just getting way more physical than necessary. So if this injury occurred during one of those drills, then it's possible that this liability release would be invalid or unenforceable if the injury was caused by some sort of intentional act. So broadly speaking, stepping back, again, the first thing we need to address and figure out is whether or not the terms of this liability release are ambiguous in any manner, and then second, whether or not this individual is injured as a result of some sort of intentional act above and beyond just mere negligent conduct.
Okay, so if this release is indeed invalid, does that mean the league ends up paying for it?
Well, not necessarily. That's kind of where I get back to that point earlier where I said there's going to be a lot of different variables that play a role outside of this liability release. And just because someone sustains an injury doesn't mean that some other party is going to be responsible for it. There still needs to be a legal basis to hold another party liable for any sort of injuries or damages. So as another example, let's say a hockey player suffered a really nasty cut from a skate sometime before or well after a hockey game. Well, that doesn't necessarily mean that the hockey league did anything to cause the injury or that is going to make the hockey league responsible to pay for those medical expenses. And when we talk about sports, we also need to acknowledge that there is an assumption of risk that injuries can occur anytime someone's participating in them.
Okay, so with that assumption of risk, we've got a minute left. How does that affect the liability release?
Well, again, biggest thing we need to remember is that we're talking about sports here.
Right.
So whether it's football, hockey, soccer, volleyball, you name it, there's always going to be an inherent risk that an injury can occur. So when this individual asks if the sports league is going to be responsible, we need to first acknowledge that this injury could have been that inherent risk that would have happened regardless. So how this plays out in a practical sense in the court of law, a jury may say, hey, the hockey league or sports league isn't responsible. You as the participant assume the risk of this injury by participating. So again, a lot of different variables that play a role with these liability releases.
All right, as always, good information, and we thank you so much for being our guest today. It has been Tyler Siewert. He is from the law firm of Schweiger, Clemeen and McBride. And a quick reminder for you, the information that we talked about here today does not pertain in all cases. For more information, you should contact an attorney.